Is Durham getting ready to charge people with a conspiracy? Why the long indictment? Why those Perkins Coie records? Well, let's go to the piece. He says, so on what basis then was it likely determined by a court that the attorney-client privilege did not apply and Perkins Coie had to disclose the records? Perkins Coie billing records. These would be subjected to legal attorney-client privilege. Everybody tracking? So he says, well, how is it that Durham got a hold of that if they're privileged? Well, Durham had to find a way around the privilege to get them, right? Ship says, well, that's the $64,000 question. We may not know the answer for some time, but the most likely justification for ordering production of these privileged records to Durham, the prosecutor, was the crime fraud exception to the attorney-client privilege. Simply stated, yeah, you see where he's good. This is just a gemstone right here. Simply stated, the crime fraud exception applies when the communications or records at the law firm at issue involve a future crime or fraud under consideration or a crime or fraud currently underway and continuing. The focus of the inquiry is on the client's intent, not the attorney's intent. The attorney-client privilege will be negated by the crime fraud exception, regardless of whether the attorney's aware of or involved in the client's crime or fraud. Who was the client again of the attorney? Who was the client again of the attorney? Who was the client of the attorney? Yes, the Clinton campaign. So if John Durham got his mitts on those legal records, even though they were privileged, was the reason he got his mitts on those legal records because John Durham is getting ready to charge people in the Clinton orbit with a conspiracy and they were evidence of a crime? Seems awfully odd he would draw up a 27-page indictment and include all that if he wasn't putting little breadcrumbs here and there. I'm like actually getting goosebumps because I've been following this case for so long. Let me just be clear again so you don't mistake me for others who do this kind of stuff. I don't control the DOJ, ladies and gentlemen. I have very little optimism that the Department of Justice will view this case fairly and do the right thing. I'm simply stating to you an obvious fact that Ship's analysis here is correct. Why the hell would Durham draw up a 27-page indictment, largely irrelevant to a false statements charge that includes a legal firm's billing records that are obviously attorney-client privilege if the client, the Clinton campaign, wasn't a part of a conspiracy? Why would you write that in a legal document you know everybody's going to see? It doesn't make any sense. Unless you were looking to do something with it later.